Hi, I'm Tabitha Coe. I'm the Legal Director at Northwest Surrogacy Center. Welcome to our legal overview for intended parents.
And my name's Heidi Martins. I'm the Legal Services Coordinator here at Northwest Surrogacy Center.
So first I want to tell you a little bit about Northwest Surrogacy Center. We were founded in 1994 and we're the biggest surrogacy agency in the Pacific Northwest. We celebrated 154 babies born last year through our agency. We work with LGBT and straight families from the U.S. and from around the world. In fact, at this point, most of our intended parents are international families.
As far as surrogates go, we are currently working with women in Oregon, Colorado, and California. Our main office is here in Portland, Oregon, but we also have satellite offices in Denver and San Francisco. I work as the Legal Services Coordinator, along with also being a case manager, and my role is really just to support everyone, all of the parties, intended parents, and surrogates, and also the independent attorneys that you're working with through all the legal pieces of this process to help with good communication and problem solving along the way.
As the legal director, I help parents with legal questions that they might have at any point in the process, from where you are today all the way through going home with your baby. I oversee the contract process, the referrals of you to independent attorneys with Heidi, and I help to facilitate the establishment of your legal parental rights, again, working with the attorney in the state where your child is going to be born. Over the past 24 years, we've worked with hundreds of clients from 23 different countries, and all of our families have gone home successfully with their babies after surrogacy. So that's the heart of this matter. It is a complicated process, though, especially so for international families. And we really encourage you to consult with a lawyer in your home country who has experience with surrogacy. We're happy to help connect you with that person if you don't have a contact yourself, to really get information at the beginning of the process, at this point, in order to understand what you might need to be aware of as you move through the process. I'm available and Heidi's available to help coordinate conversations with those attorneys at any point from day one through your return home with your baby. The process involves, of course, medical components, social components, administrative, financial, and legal. And what we're going to focus on today is an overview of the legal process from your perspective as intended parents. I just want to remind everyone you can send questions at any point as we go along. If something triggers a thought, please send a question. We're going to save some time at the end to get into as many of those as we can. Okay, the surrogate contract. So there are two places in this process where you will interact with Heidi and with me. The first one is the surrogate contract. After you are matched with a surrogate, your case manager has overseen a meeting for you, and assuming that's successful and you've decided to move forward together, your file comes to us.
And so that is where I pick up with assisting in reviewing the file along with the attorneys involved in this drafting process. I'll also be making a phone call to your surrogate. Besides working with our legal team, I've also been a case manager for 4 years. I'm used to talking to surrogates. I like to help them feel prepared with what's coming up next, but I'll also, in that phone call, be confirming some important information about wages and things like that, just to make sure we have the most up-to-date information at the time we're putting this contract together and it's going out to you and the attorneys that are going to be involved. So I collect this information from your surrogate and I pass it along to our drafting attorney who will actually put together your draft. Once that is completed, then I am notified and I assist in getting that out to everyone. So you have a good email from me to be in touch with me with questions if anything comes up, and also the attorneys that are involved in the contract process. If you have a particular attorney you want to work with, that's just fine. Please make sure that your case manager is aware so that I know. So when your contract is ready to go out and I send it to you and I send it to your surrogate, I also send it to the correct attorney that you're hoping to work with, and we don't waste any time starting off with the wrong attorneys. And another important note that I have found for families that want to get things moving quickly, every state is a little different about how the attorney can be in touch with you if you are using a referral from us. But no matter what state you're working in, things always move forward most quickly if you reach out to your attorney directly to initiate that contract review process. They'll be a lot faster if they have an email or voicemail to reply to from you than just waiting for them to reach out directly.
Yeah, and that's a great point. These attorneys are independent attorneys representing you and representing your surrogate. So although we help facilitate the process, we're very much available to everybody. Their commitment and their responsibility is to you as clients, and so you have the greatest sway with them when it comes to moving things along. We will keep your case manager copied along the way, so that person will remain a point person as you go through this process. And each attorney has a different set of ethical rules based on their state that they're following. And so the most efficient way to move forward here is for you to reach out directly. Mm-hmm. I just want to acknowledge that by the time you get to that attorney contract review, you will be impatient. Everybody's impatient at that point. You have waited, you've had your match, you've met the surrogate, you've fallen in love with one another, you're ready to move forward, and now you have to go through this legal process. And I would encourage you to both move it forward efficiently, but do take the time to honor this as a serious part of the process. Typically, it will take somewhere between a month or 3 weeks and 5 or 6 weeks to finish the contract review. That allows for you to and your partner or spouse, if you're doing this together, to take your time going through every provision of the contract, to meet with your attorney, to consider a red line with revisions, to have your surrogate do the same with her partner or spouse and her attorney, and to allow for some exchange back and forth. The contract covers a lot of different subject matter. It covers details that are your surrogate's commitments to you and your commitments to her. The heart of the contract is your intent. It is setting out your intent to be the parents and her intent that you are the parents and not her or her spouse if she has one. It also will cover financial and medical details, a whole lot of details related to those matters, the managing of the escrow account, all of those pieces, and then a whole array of social and behavioral provisions. So the things that the surrogate is promising to do or to not do during the time that she's pregnant with your child and working on getting pregnant. I want to take a little bit of time to jump off of what Heidi said and talking about attorney selection, because it's not uncommon for intended parents to have questions about how to choose an attorney and how that works. The referral that Heidi will provide to you is for an experienced attorney who we believe is competent and knowledgeable in the state where your child is expected to be born, where your surrogate lives. I strongly encourage you to use an experienced attorney. If you have a surrogacy attorney already in mind, that's great. You'll let us know, and we'll make sure to smoothly facilitate that process. But it's a very specific area of law, and I would be very cautious about you working with a different attorney, maybe a friend or a family member, a general family law attorney who you would like to use in this process. Part of what you're looking for in an attorney is not just to explain your rights and responsibilities under the contract, and it's not just to help you negotiate any modifications that are really important to you that weren't covered in the initial draft. The attorney also is really a resource for you in talking about the standards and the norms of surrogacy in that state, and helping you to understand the context that this contract and this relationship comes into. Most of you won't do this more than once in your lifetime, and we don't expect you to know everything there is to know about surrogacy law and surrogacy contracts. We do expect your attorney to do a good job supplementing that, and for you, supplementing it really from an independent perspective. So one mistake that I sometimes see families make, or or attorneys make who aren't experienced with surrogacy is coming into this contract process from a hardcore adversarial negotiating position. If you enter into a contract with your surrogate where your attorney has really managed to get the most out of it in this relationship, then you've made a mistake from the beginning, because the relationship with your surrogate and your mutual respect for one another and your mutual trust is essential to this process going forward. And so the attorney should protect you from exploitation, answer your questions, advocate for you, but also foster that relationship with your surrogate for the year that's ahead of you all together. Let's see.
And so then the next step, of course, comes once all this contract is wrapped up. There are some states that require special signing or notaries. Please rest assured you can talk with your attorney on how many copies you need to sign, where you need to send hard copies. Your attorney will be there to assist you with that. But of course, also, again, we're a resource. But once that big day has finally come, things are signed, NWSC will be eager to get a copy of that contract. It's important for us to get that, so one, we know that it's been signed, and it's also a big trigger point for the next step in your process, which is to have this signed, finalized contract reviewed by our financial team so they can create your trust estimate. They'll be sending this estimate to you with the request for those funds. Your case manager will go ahead and get your surrogate started with the beginning stages with your clinic, but you will not be able to begin the IVF medication for your transfer until that full trust has been received. So do let us know when you sign your contract. Send it to your attorney. If you also want to send it to me and your case manager, that's great too. We like to get the copies of those for obvious reasons, and it is important to begin the next step, which is to get pregnant, which kind of leads us in then to the next time that you will be hearing from our legal team. So once you are pregnant, after the first trimester has completed, usually around 18 weeks, you will receive an email from me. And this is to remind you and the attorneys that you have worked with to get the ball rolling with legal parentage work. We are here as a resource to help connect you with Tabitha if you have questions, and again, reconnect you with your attorneys. You are welcome to work with the same attorney in the contract process for your parentage, or you may also choose a new attorney.
So as the director of the legal department at Northwest Surrogacy Center, I'm available to each and every intended family as you go through this process for consultations or questions. I'm also frequently in contact with your attorney in your home country who might have questions or want to understand a little better about the context, or might wish to have me facilitate a call between them and the attorney in the state where your surrogate is delivering. There are some differences in establishing parental rights between Oregon, Colorado, and California, and I'm not going to go into those in a lot of detail right now, but it's important for you to know that in each of these states, your names will be on the birth certificate as the intended parents. There is a pre-birth process available in each of these states. There are also sometimes reasons that a family will choose a bifurcated, a divided process, or a post-birth process. And that will really depend on the circumstances of your home country, what's needed to make life work for you there, and the advice of your individual attorney in those cases. All of these states are surrogacy friendly. All of these states, in our experience, have been very welcoming and supportive of same-sex couples, as well as traditional couples or single parents who are going through this process. So my expectation for you is that wherever your surrogate is delivering and whatever state is handling your legal process, that you will be respected and acknowledged as the legal parents and treated well as you go through this process. Again, I said this 10 minutes ago, it is so important for international families to have a contact with a local lawyer in their home country or some source for legal advice and information, because there's a lot that we can do on this side, on the U.S. side, to get you the documents that you need, the birth certificates that you need, the additional paperwork you might need. but the attorney in your home country is really going to guide and dictate that process. None of us are licensed to practice law in France or China or Spain or the UK or Australia, any of these other countries where you might live. So please reach out to that local person and encourage them to reach out to us early in the process so we can all work together to ensure you have a smooth transition home with your children. I guess I'll say just a little word about costs. Of course, that's big in everybody's mind. When you're going through the contract review, the typical range for the surrogate's attorney is somewhere between $1,000 and $1,800. Depends on the state and it depends on the attorney. For the intended parent attorney, your attorney in that process, it's typically somewhere between $1,200 and $2,500 for the attorney fees in that process. Many attorneys will charge a flat fee, but some of them will do this on an hourly basis, so it really depends on who you're connected up with there. When it comes to the cost of the legal process for establishing parental rights, getting the birth certificates, navigating the process with the hospital, passport, Social Security, all of those details. Those are in the hands of the attorney doing your final legal parentage. And the total cost for surrogate's attorney, court fees and costs, and your attorney typically will range between $6,000 and $10,000, again, depending on the state, depending on how complex of a process you are requesting, and depending on the individual attorneys involved. I think the next thing that we had to sort of address off the bat, I'm trying to presume which questions everybody will have, really gets to the birth certificates. So in every one of these cases, we expect that in the end, at the final stage, your names will be listed on the birth certificate. That's whether the child has two fathers, two mothers, a mother and a father, or only one parent. The child's name will be the name that you have chosen, the name with your last name, and whatever first or middle names that you have selected. The process varies a little bit between the states. For example, in Oregon, the change happens at vital records, and so the hospital will report the fact of the birth in the name of the woman who has delivered the baby. That's the statute here. As soon as that happens, your attorney will provide a certified judgment to the state of Oregon, directing them to place your names as the parents on the birth certificate and to issue however many copies of that birth certificate you need. In California and Colorado, the process is a little different. With a pre-birth order, the order actually directs the initial report of the birth to be in your names. And so the experience from you of receiving a birth certificate somewhere between a few days and a week after birth with your names on it is the same, but the behind-the-scenes process that the attorney and the administrators are going through is a little different. In each of these states, if you have a need, as some intended parents from from other countries do, to have a birth certificate that begins with just one father or one parent, and then later adds the second parent, for example, through a second parent adoption, which is common to do here in Oregon. That process is also available in each of those countries. It will look, states, it will look a little different, and I would just encourage you to work with your specific attorney there to find the best path for you as you navigate the process. Again, it's no issue, no difference between straight parents and same-sex couples. Your names can be on the birth certificate without any problem here. Let's see. In terms of the timeline, I think it would be anywhere between a few days here in Oregon to a week or even 2 weeks after birth if you've chosen to have a post-birth proceeding rather than a pre-birth proceeding. So thinking about your timeline for travel, what your needs are for the birth certificate as you go through that process will help the attorney really plan out a smooth process for you. And I think the next thing that we wanted to talk about is passports.
Yeah, other than just saying, as we have a few times, keep track of my email. Of course, your case managers will also be very helpful in this process, but you are welcome. With my experience as a case manager and my close relationship with Tabitha and working together on the legal team, we're here as a resource. So if you have questions, just ask. We're available.
That would really go throughout the process. So your case manager will be holding your hand in a virtual way. Katie can, I mean, Heidi's been a case manager enough to know that hand holding sometimes is real when you're here with us in Portland, but it's always there virtually. So they'll be there throughout that process. But we love solving problems, and as you work with your attorney, your home country or your home state, and the attorney in the state where your surrogate's delivering, we love to hear feedback as you go through that process and to be kept in the loop so that we can jump in and offer assistance wherever possible. The passport really is, for those of you who live abroad, the last big gate to get through so that you can get on a plane and go home. And it's really exciting when you get to that point. It's also a little bit stressful, and it's another bureaucracy that you're dealing with here, which is unfamiliar to you and requires a little bit of guidance. So just to give you a little bit of context, once you have a birth certificate with your names on it, you can apply for the American passport. Your children are American citizens because they are born here, and that's according to our federal law. So there's not any concern about them being eligible for an American passport. It's just the process of going through the bureaucracy and meeting those requirements. The quickest possible way to get that American passport is to take the birth certificate, take a passport application, your own identity documents, a photograph of your child that's been taken by an appropriate passport photographer, proof of your travel, and go to a passport office. There are ones in Seattle, San Francisco, Los Angeles. In fact, most major U.S. cities have a passport office, and apply in person for that American passport. When you do that, you will usually get the passport issued either the same day or within 1 or 2 days afterwards. That is, without a doubt, the most efficient way to get the passport. It's also the method that allows you the greatest control. You're there, you can answer questions, you can explain why your name has an accent mark, you can explain anything that comes up for them. It's also quite difficult and inconvenient for most of you. You have a brand new baby, and you're eager to get home. You don't want to have to drive here in the U.S. You may not want to have to travel. And so there is another option that the majority of our families actually use. That is to utilize a third-party passport expedite service to obtain the passport for you. In that case, you are preparing the application, assembling the information, and visiting a local acceptance facility. Could be a courthouse, it could be an administrative office or a post office in whatever town you're in with your baby. And then you send that packet out by overnight mail, and the service helps you to get the passport. That's a great option for a lot of people. The downside is that if there's any question that comes up, you need to be prepared to deal with that remotely, and it can take a day or two. And so typically you have your passport within 5 or 6 days using the expedite service. If you're very anxious for time or you're down to the wire, I would recommend that you go in person. There's a third option. Some of our families have the opportunity to actually remain in the U.S. for several weeks or even a couple of months after their baby's born. Families that have friends or a close family that live here in the U.S. or for other reasons are choosing to remain before they travel can just use an ordinary application by mail and get their passport within 2 or 3 weeks that way. As you go through that process, your attorney will be helping you, will be available to answer questions, and really do whatever we can to get you to the point where you have your passport in hand, you have your baby, you have your birth certificates, and you're ready to go home. I think at this point, we're ready probably to begin taking questions. Just going to give a minute for them to come through to us.
And fix my necklace in the meantime. Okay.
Okay, so good question. If you don't speak English and yet you're needing to navigate this fairly complex process with us and with your attorney, how do we suggest that you manage that? So, of course, many of our clients, English is not their first language. It is very important that you understand the legal terminology and the legal commitments that you're making. Some of you will have an individual who's already helping you to navigate the process, who is fluent in your home language, and that person you may invite to be the translator throughout the legal process, including helping you in meetings with your attorney and meetings that you might have with us. You're welcome to use that individual. Some people have a close friend or family member who they will ask to assist them with interpreting at live meetings and translating the contract. And others, we will just recommend that you have an official translator. We have resources available to book those translators in advance of Skype meetings or to bring them in for in-person meetings with you. Your individual attorney also will have specific thoughts about this, according, again, to their professional responsibility code. And so I would encourage you to communicate with them as well, and we'll be available to guide you through that process. Next question. Okay, great question. Heidi, does this ever come up for you?
Yes. So the question is, what if something changes with my surrogate after we sign a contract, like if she changes jobs or moves? And that definitely happens. Your surrogate is a human that has a life and has a family, and things will happen in her life that may cause the situation to be changed from what you originally signed in your contract. We try to draft the contract in a way that there's some fluidity with that, but if you have questions because changes have occurred, again, your case manager can help put you in touch with the legal team and kind of walk you through what we've done in past experiences.
That's right, and often that means reaching out to Heidi with you, explaining the situation, and we will take the lead on helping you figure out whether you need to amend your contract to address this, or whether it's one of those changes that you can simply notify each other in writing. There might be a change in your circumstances as well. You might get married, you might change where you're living, you might change from using your own eggs to using donor eggs. All of these are circumstances that we will address as much as we can in the contract to anticipate some, as Heidi said, some flexibility. But if it happens that there's a change that is not already encompassed, we'll be available to help guide you through that process. It may mean that we prepare an addendum that we email to you and your attorneys to review and really expedite getting that adjustment made efficiently and quickly. Next question.
Will the hospital have the documents that prove I'm the parent? And that is something I'm sure Tabitha will touch on as well. But your attorney should be sending some of these pre-birth documents so they know who you are, they understand what the situation is. There'll be a birth plan that's been worked out between your attorney and your surrogate's attorney, which is, of course, you and your surrogate's input, that will help everyone be fully informed of what the situation is and who all the parties are that are going to be there for the big day.
Yeah, there really are sort of three phases to that legal process, and the first one is focused on the hospital. And so I can speak to the typical protocols in Oregon. Your surrogate would sign a power of attorney and a custody agreement that are informing the hospital that she is delegated to the two of you, or the one of you for single parents, full authority to make medical decisions for the child, to have the child in your physical care and custody, and for you to be discharged from the hospital with your child. That is sort of a supplement to the actual legal process, which will involve a court judgment declaring that by law you are the legal parents of your child and your surrogate is not a legal parent. My philosophy really is that we want this process to go as smoothly as possible for you. And so that means both addressing the court proceeding pre-birth if at all possible, so that you walk into the hospital for the delivery already legal parents, but also giving the hospital whatever other documents will make them comfortable and make them relax and understand your role and your situation. The third part of that legal process is what we've already sort of described: getting the birth certificates, getting the passport, getting apostilles, any other documents that you might need to navigate the process of returning home with your child. Let's see. So, documents approved. Okay, the next question. Other than in California and Oregon, what other states have a similar favorable environment for surrogacy? So this is a really broad question. Northwest Surrogacy Center works with surrogates in Colorado, Oregon, and California, because those are states where we are very confident and comfortable that the legal process will be supportive and welcoming for you, whether you're international or domestic, whether you're a same-sex couple, a straight couple, a married couple, and also because those are all states where we believe that the surrogate population and the women who are available and interested in working with us are fitting the profile that you and your doctor and your lawyer are going to want: healthy, responsible, committed people. There are a lot of wonderful states out there, so I'm not going to say anything against any individual state, but I will say that we're very confident with the programs that we have in Oregon, California, and Colorado. Great question. So I'm going to take this one, yeah, Heidi. We have somebody asking, could we please talk about parents and surrogates that live in Washington, in Seattle, Washington, or elsewhere in Washington. So Washington State is one of those jurisdictions that has specific law prohibiting compensated surrogacy. And that really affects you in two ways there. One is that you're breaking the law if you, as a surrogate, are serving for compensation as a carrier for somebody. So it's also a violation of the law if an attorney who is practicing in Washington is facilitating a compensated surrogacy for a Washington surrogate. The other way this impacts you is that a contract for compensation is actually void. It's not enforceable in Washington. And this is a really big deal. The contract is the fundamental document that sets out the expectation, the intention that you are the legal parents of this child and that your surrogate is not a parent. If that contract is unenforceable, that's a big problem. It also sets out the commitments that you make financially to your surrogate to pay her and to follow through on certain obligations. For her, big problem if it's not enforceable. So that's why we don't work with women who are residing in Washington State at this time, in order to protect everybody from falling into that circumstance. Just a word about Washington families who are working with surrogates living in Oregon, California, or Colorado, participating in contracts prepared by attorneys in those states, and working with an agency that is located outside of the state of Washington. That is a circumstance that we are comfortable with, and we are happy to talk with you about further concerns or refer you to Washington attorneys also if you have other questions on that matter. Here's a question about drafts from one lawyer to another. So every family working through our program is going to get an initial draft contract that we've prepared. And there are going to be a lot of similarities in those contracts. This is actually an important part of our policy because there are huge differences between agencies, attorneys. There are different views, there are different ethical views, there are different senses of what's appropriate. When you are working through our program, we believe that you have certain expectations that you've gathered from information we're sharing you in webinars like this, in your meetings with our founders, with our team. The surrogate's also getting information as she comes in through our process, through our intake process. She's had extensive interviews, information provided to her in writing, information on the website. And we think it's important that you all don't get surprises when you come to the contract phase. that you have the expectations that you have been led to believe are followed through on when you come to the contract phase. So it's a balance there between you having independent representation who can help you with specific changes that you need without providing you with a whole new vision of your surrogacy after the point of match when you're ready to move forward with getting pregnant. Okay, I'm going to ask for a minute. This is kind of a long conversation. Okay, the question, I'm not going to read the whole thing because it's actually quite a long question, but the heart of it is solving problems between attorneys. So this is a sensitive area, right? There are a lot of attorneys working in this area with varying experiences, varying backgrounds, and varying sort of ethical perspectives. Also different sort of administrative perspectives. And attorneys are not a population. I can speak to this as a practicing attorney of many years. And I practice in 3 different states, so I have 3 different sets of ethical rules I need to follow. Attorneys are strong-minded and opinionated, and your attorney will make their opinions known. We actually pay close attention to which attorney pairs work well together. You need an independent lawyer who is advocating for you. But if your attorney and your surrogate's attorney have very different perspectives on the process, that is not going to be a smooth negotiation process, and it's actually likely to lead to a prolonged and maybe I could even say dysfunctional contract process. We don't want that for you. We want it to be good advocacy, but an effective and smooth process. And so we will actually be thoughtful in who we refer you to and your attorney to, you and your surrogate to, that these are attorneys who can work effectively together. Having said that, there are also some times that you will change attorneys, or you might choose an attorney and the thoughtful match that we made doesn't work out. Some of those attorneys will actually be forthright in letting you know, I don't think it's going to be a great idea for me to represent you if your surrogate is with this attorney because we have a very different vision of the process. And I would encourage you to listen to that. If you notice that something is going wrong in the negotiation, something doesn't feel right, it feels like maybe the attorneys are impeding a process that otherwise would go smoothly, please let Heidi and me know right away. We'll do what we can to help with that. Obviously, we can't intrude in the attorney-client relationship, but we are here to help guide that process. Okay, what kinds of things will be covered in the surrogacy contract? So this is a question wondering about some of the more details like contact during the surrogacy, health considerations in the pregnancy, decisions about who's at the birth, what kind of monitoring and appointments you're having. How do we decide which of these things are in the contract and which of them are not? So again, this is a great point. In the match meeting with your case manager, you and your surrogate will have an opportunity to talk about a whole lot of these things with the facilitation of the case manager. And part of our vision is to make sure that you address explicitly those things that are questioned. So Heidi, what are some of the things that come up in match meetings that are really important to get through into the contract?
You know, I think some of the most important things might seem rather basic, but for some of our intended parents, we like to talk about those basic things like not smoking or doing drugs or drinking alcohol during pregnancy. That is something that will be brought up in your match meeting, and it is something that's very much in your contract. In the match meeting, you talk a little bit about what the surrogate's previous pregnancy was like, which will help give you an idea as intended parents what kind of appointments she expects to be going to. You know, you go once a month to the doctor at the beginning of the pregnancy, and you start being seen more frequently at the end of the pregnancy. Some of these things that may have been concerns for parents, like, you know, how often is she going to be seeing the doctor? Is she going to be following doctor's orders? Become very apparent in that match meeting that she has gotten medical advice before and listened to it and goes regularly to appointments. And you get to see that expectation in her of what a normal pregnancy looks like. And it can go a long way to help you feel more comfortable. And then those things also shift and are addressed in the contract, that she will be following doctor's orders and attending medical appointments and getting you information after those appointments on how they went and what was learned there.
And one of the things that might come up in your match meeting is if there's something that's a particular concern to you or a particular concern to your surrogate. So your surrogate may, for example, feel that it's really important that she have a doula with her for her delivery, an extra assistant, or that she have her mother and sister who were there for her own deliveries there, and she wants to be sure that you know this is really critical to her, so you can't be anticipating a delivery that will be just you and her, that she has a different vision. You might share with her that you have a significant concern about some element of her pregnancy. And if that's something that's really raised as an important element in that match meeting, we'll get a note from that in the file, and we review all those notes when we prepare the contract. And I would encourage you to be sure that it is mentioned in the contract, because if something feels really critical to you or critical to your surrogate, it's important at the very outset to be sure everyone's on the same page. Of course, the contract will address the things that we know are critical, like abortion, selective reduction, the number of embryos you're planning to transfer, her willingness to give you medical records and to allow you to be present at the birth, or at least to be in contact with the doctor and informed about that process. Let's see, here's another question. Before birth, do the discussions with our attorney only concern the choice of which name should appear on the birth certificate, or are there other issues to discuss? Good question. So there's a huge issue to discuss with the attorney, which is how do you become the legal parent of your child? And that is the most fundamental part of their role. So the name that's listed on the birth certificate is a reflection of an underlying legal process to establish that you are the legal father or mother or parents of the child. The transfer of the birth certificate, of the name onto the birth certificate, is an offshoot of that legal judgment. But the attorney also will be helping you navigate the process with the hospital if there are other documents they require, and also be helping you to navigate getting the birth certificates and getting those other documents that you need to get home and move on with your relationship. There was a second part to that question, and I'm wondering, let me just see if I can see it. Oh, okay. Sorry, we're moving on. You guys are sending us a lot of compound questions, which I appreciate, but I'm trying to do my best to get at all the pieces of them. Does the relationship with the surrogate need to go beyond the pregnancy and birth? This is a great question, and this really is such an individual process, what that relationship looks like. Almost every case involves at least some contact after birth. That may be just sending a Christmas card showing a photo of your family, or a birthday picture letting her know how the child is going. I don't think any woman who participates as a surrogate for you is not going to be interested in knowing how you are, how that child is faring, and that you're all doing well in the world. Having said that, this is your child, and it's your family, and it really is for you to guide and, I won't say dictate because it's a collaborative process, but for you to direct what you want that relationship to look like. We will have several points as you go through the process where we're talking with you about your wishes and your vision for that process, and try to do a good job of matching you with a surrogate who has a similar vision. And so that if you're someone who's looking for really a lot of involvement, want your surrogate to be someone that you can visit and that will answer questions if your child has questions in the future, we want you to be with a surrogate who has a similar vision. If you are someone who really wants to appreciate her and thank her and then move on to your life with greater distance, it needs to be clear from the outset that that's the sort of relationship that you're looking for. This is a supremely human process, and it involves a match between your family and her family. And so we will do all we can to guide and help you navigate that, but fundamentally it's going to depend on you and what kind of a family you want to have. Termination for medical reasons, right? This is a very important question. So here's a question of intended parents who are faced with a medical problem with their child during the pregnancy and are trying to face the decision of requesting her to terminate that pregnancy. It is, and the question is pointing out that this is in some fundamental tension with the surrogate's bodily autonomy. You are absolutely right. There are several points in this process where the idea of autonomy for the woman carrying your child and your decisions as parents for your future child will be in tension. The best I can say about this is to talk it out well in advance. So you will be talking about this issue of termination from the time you start the process. And so will your future surrogate. She'll be talking it through, talking about it in the psychological evaluation. She'll be talking about it probably even at the home visit. She'll be talking about it with her intake coordinator, with the case manager, in the match meeting, with her lawyer, and you will be doing the same throughout the process. And that's because the best way I know to set you up so that if you face that decision, which hopefully none of you will face, most intended parents don't face, but some certainly do, and we've been through families with that very difficult decision. When you come to that point, it should not be a novel question. It should not be the first time you've grappled with it. And so even though it is unpleasant and difficult to talk through and think through as a couple and then with your surrogate, I encourage you to really do that early in the process. Fundamentally, the surrogate will have made her own decision and articulated it, that this will be your responsibility as intended parents to make that call. And you will be trusting and relying on her that when it comes to that moment, if you have to ask for that, that she will be able to draw on that, rely on that, and follow through on your wishes. And for what it's worth, every time I've seen somebody have to grapple with this decision, it's been very challenging for everybody involved, and it has been resolved in following the intended parents' wishes and going through that process with them because ultimately you're the parents of the child and you're the ones that know what you can and cannot take on as parents. I will actually say a word about termination in a non-medical context. So that would be contrary to most surrogates' views, contrary to our agency's policies, contrary to medical ethics in many states, if not all states, to consider requesting a termination of pregnancy for a reason that is not a serious medical reason. And so I would really urge you, if that is something that you have in mind, the opportunity to terminate based on gender or a non-medical problem, that you think long and hard with that and talk about it with Northwest Surrogacy Center early in that process, because that's something that you're likely to find is a significant challenge to you. Last question. Oh gosh, and we've actually, we have run a little late. So if I decide to have a second baby with the same surrogate, can I just copy and paste the contract? So the answer is no. You should not just copy and paste the contract. You will want to revisit the legal terms of the contract with an attorney. We are happy to work with you to try to help facilitate that process being smooth and efficient, to be as affordable as possible for you. But surrogacy is a changing process, and so the terms that might be in there, for example, related to something like insurance, something that is very complex and very moving, may not be the same from one situation to the next. And to skip over the legal review and the clarity in your contract in something as important as the child that you are planning to parent would be a false economy for you. I would not recommend that you do that. So I just want to say thank thank you to all of you. Thank you for your questions. Thanks for being so engaged in the process and so interested in learning. We are going to send out a recording of the webinar, and you're welcome to contact us directly if you have any other questions. We really look forward to your feedback, so please be honest and concrete in your feedback so we can continue improving. Have a great day.
Yes, thank you.